David's trying to run against me for judge of probate.
Oh, not this guy.
Yeah, I'm running on that. Yeah.
It's too bad I'm not a captain.
Or doesn't have competency.
Where you come. He helps you.
Keep me up together. Where are you?
Oh, is this you?
Oh, no shit. I'm
See right here. Is it first?
I just called the number I have for you.
Yep, it might be this person. I'm just waiting for Jefferson to.
Oh, she's on that, two defendants, right?
Yes, I thought, yeah. She said.
That's right.
Yeah.
Oh, okay. You want me to finish this part first? You want me to finish this first? Yeah.
May I can call it, Judge, I got, ready on the 10:15.
Okay, let's do it.
How come it's not showing up there? Because nobody's logged on? Calling case number 2060706, the people of the state of Michigan versus Shaitan Berry. The defendant is charged with count 1, false report of a felony. This matter is scheduled for exam.
Good morning, Your Honor. Asia Lewis for the people, PA 5520.
Good morning, Your Honor. Attorney Daniel Lacier, P 72620, representing defendants. State your name, please.
Shaitan Lynette Berry.
There's date, time set for preliminary examination. Are you ready to proceed?
Your Honor, the people are not ready to proceed. The people will be dismissing this case against this defendant as the officers in this case can no longer make an ID, and the video evidence that is necessary in this case is no longer accessible.
All right, court will dismiss this matter without prejudice.
Thank you, Your Honor.
The dismissal order, Mr. Spencer.
Good morning, Your Honor. I apologize for rejecting. I was here for an 11:30 exam for defendant Taylor, and I was told the counsel was not going to make it. Am I in the right place?
You're told that who's not gonna make it?
I believe it was Michael Lamb for the defendant's name is Travion Taylor.
Attorney Blake is in trial still. He called me this morning, early this morning, said he's still in trial. He said he can't because his trial started at 8:30.
He doesn't take any breaks.
I'm a couple blocks away. All my witnesses are still subpoenaed, so if the court would rather me appear in person, that would be fine as well.
Asking for adjournment for June 17th.
Cool.
the
That's
attorney.
not here.
Yeah,
Oh, okay. Also, you already.
yeah. I didn't know,
Okay, so.
I was trying
let's
to-
call and-
okay.
17, what time?
Calling case number 2457267, the people of the state of Michigan versus Travion Taylor. The defendant is charged with count 1, motor vehicles operating a chop shop. Count 2, stolen property, receiving and concealing motor vehicle. This matter is scheduled for exam.
Ryan,
Yes, for the record.
oh, thank you, Your Honor. Ryan Lukeski for the people, P73132.
So prosecutors in trial.
No, the defense attorney, just the prosecutor.
Oh, he's the prosecutor.
Yep, Ryan.
Good job. Oh. Okay, so, sir, the defense attorney on this matter is in trial. Discussed another date with our clerk. They came up with the date of June 17th at what time?
10 o'clock.
June 17th at 10 o'clock. Does that work for you?
That's a good date for the people.
All right, the court finds good cause for the adjournment. I'll adjourn to June 17th at 10 o'clock and bond will be continued.
Thank you, Your Honor. And Your Honor, I had, I believe it was a previous PCC, and I sent all the discovery to a Mr. Lamb. Am I to understand it's Mr. Blake now? Maybe they work together, I don't know.
It's retained by Mr. Blake.
It's retained by Mr. Blake. Okay.
Yeah, right, Blake.
I will forward everything I have to him. Thank you, Your Honor.
All right, thank you.
Yeah, I think agent understands. And the system is Blake. I don't know, maybe he got retained right after the PCC or something. There you go. Welcome.
Take care. Hey. Okay. I know.
Oh. Sometimes I think it's just the courtroom that they come to, Mr. Lee, but it's not gonna get, it doesn't matter. If they late in one courtroom, they're gonna be late in another courtroom.
I'll figure something out. Take it.
All right.
How do you do that?
Huh?
How do you do that? You just put it in a rotation?
Control the camera.
Oh, no.
Say hi. Everybody say hi to Kitty. Yes. I'll be right back, guys. We're gonna handle the PCC real quick.
Okay.
Roller skates in full effect.
Got the next story.
I know, right? And again,
Yeah. Huh?
oh, he's-
Oh, I thought somebody started.
yeah, he kept.
Huh? I was like, I know he don't still have me on there. About to go give me a donut.
Where they at?
They're in the judicial conference room.
Go ahead, girl. Yeah, tell him.
There is enough for one per person. Oh, it's a limit on the donuts. Watch this.
Didn't bring too many.
I'm about to call,
Didn't bring too many in.
Joyce.
They go get it, but.
Joyce, is a limit on the donuts?
Until there's that tonight. Okay. What case you want, sir?
Oh, Eric Jones.
All right, I'm on, okay. All
And you are the one seat?
right, I'm gonna give you donut.
Okay.
How you doing today?
Good, how are you?
Tired, ready for back to bed.
Man, how many years you got? You think about 39. You think about retiring soon?
Well, I told my daughter I do 4 years, 2 years in the university.
Okay.
So,
Cause you're not doing nothing hard now, right? Easy, okay.
You can tell how easy it is.
Right.
You come in, easy like Sunday morning.
This is his guy, he's like Sunday morning.
The judicial conference room, that's on 5, right? You
I
don't
don't
know?
go there, I don't do it. They don't let me in there.
I'll let you in.
No, it's just,
They said only one per person.
Tell them you get one from me, Ken.
Wow, I'm getting one for the whole staff.
Taylor, Taylor.
Travion Taylor,
I was looking for his name, I don't see it for some reason.
let's see what they,
When he came on, that's why I knew he was the. Was on that case.
who?
Mr. Ryan, was, I knew he was on because I remember.
So who you trying to look to see who was on?
I'm trying to find one with PC was.
May 28th.
May 28th?
Yeah.
Okay.
At May 28th. I'm going to get a donut, Judge.
Okay.
It's on 5, right?
Yes.
They said one per person.
I know.
It's a limit.
No, it was Michael Lamb on that the first time.
Everything seems to be in slow motion today.
Yeah.
Did you sign with Ms. Jefferson?
No, sir. Yeah, she's one of the ones, she's kind of late.
Oh, yeah, I know.
Oh, yeah.
Judge, what time is it?
12 o'clock.
Can you do it in here?
Do what?
Do your, if she leaves, are you?
I'm feeling
Oh,
it. My
yeah.
mother's ill. I just got a call and I need to go. And I wondered if it's possible for that 12 o'clock.
I gotta move all my stuff.
Sure, that's fine.
Can you move, can you do it here?
Yeah,
I'm
absolutely.
sorry, but.
Thank you.
Thank you.
Okay, I'm gonna let Joyce know.
Thanks, Kim.
Sorry, guys. I just have so much stuff.
It probably won't even go. I'm not sure
Okay.
what kind of case it is. but
Okay,
This is my DV.
It's
CSC
assault domestic violence. It's with Margolis?
Yeah, it won't go.
Okay.
They never show up.
Yeah, that's fine. I think you're supposed to have Kathy and there might have been traffic or something.
Huh?
I know I-35, big bad house today. I
Oh,
think you were supposed to have someone else today.
Or 233 also here, we are. Who are you, sir?
My barn, I got quarter to 11.
Let me see, check this out. Barnes. Mr. Barnes, okay, yeah, that was here outside. Yeah. Okay, so you are.
Barnes.
You on Barnes? Watch go down. Okay. Hey, Mr. Bill. Mr. Bill. Can I ask you for something? Okay, we'll find out. Thank you. No, I appreciate you. Program 233. What do you have? Okay, I'll tell Judge King. He said, I'll let him know that you're 10 minutes away. Thomas and Judge. She said she'd be in 10 minutes. I said, Judge King. Okay, tell him.
Representation. Yeah, I know that's good. How you doing?
Good, how are you?
Okay.
Which one is that?
339 is right. Yeah, the scheduled cases at 11 o'clock.
Oh.
Have a trial in Judge Bryant's courtroom. So just let me know. I'll be at 339.
And you are,
Detective Smith, sir.
She's on,
you're the OIC?
OIC on Barnes, yes. So I'll be probably bounce back between both courtrooms.
Say on Barnes?
Yes,
yes, sir. That's the,
That's at 11 o'clock.
yes, they scheduled both at 11. So I'm gonna go sign into her courtroom. You need a cell phone number for me or?
No, I'll just need, I actually need this.
Okay, you see, Tracy.
I don't know, I think it was.
Got me a donut.
Okay, well, you forgot back.
Huh?
This Judge will be here about 10.
Okay.
Oh, it's in, I think they call it Jackson. No.
Huh?
If we have anything ready.
Who said that? Oh, Juanita?
Yeah.
Oh, let me call her and let her know that Judge King is in the house. She done interrupt. Thank you.
Okay. Yeah. Okay, yeah, that's what I was gonna say. At the PCC, man, wasn't.
So he must have got retained after.
Retained.
Cause it's in the system with Blake.
Yeah, once again, I don't know how he did it. I took it.
Oh, I just gotta get,
I can't get it. I wonder,
It sounds.
I'm gonna ask her about. Cause what's going on with this attorney?
Is that the right
Hey,
attorney?
Helen.
Let me double check.
Can you come up here, please? Right.
Oh, that issue? This says Bloomfield Hills.
All right, say Hannah Roberts. Did we get?
So was the wrong attorney? But they have, Attorney Hamilton, you guys have a Hannah Roberts in y'all?
So she used to work at NDS and she just recently switched, so she might still be in. And she's doing now, she's like court assigned like private attorney. So
Oh.
she's still doing it, just not with NDS yet.
Oh,
And that was Hannah Barrett.
so it is
Yeah.
her.
Oh, so wait,
No, oh, it's different.
I don't think she changed her last name from Barry that I know of.
Oh.
So wait, Hannah.
It's Hannah Roberts.
See, look, got me all convinced. I'm like, yeah, Hannah Barry.
So you have Hannah Barron that got what's her name?
Yeah.
I think it's the same attorney.
I'm about to look.
Cause Hannah, they both have the same first name and middle name, Hannah Elizabeth.
I mean, you know.
But this one is saying Roberts, but you're saying it was Barron.
Yeah. That sounds familiar, but that isn't. It's not. I'm maybe not the one that.
Well, I called the number that's on here and they were like, they were familiar that this was her case.
That's the same number you called?
Yeah, the phone number is for Hannah Roberts. It's a 248 in West Point. Yeah, like days trying to get her.
Anyways, your guys.
Yeah, right.
All right.
So it's Maybe Barney, yeah,
Oh, I was gonna take.
initially. I'm
Cody.
looking to see.
On Watts?
I think I got them. They had a read it. You know, saying who she stood, somebody stood in for somebody. You know, saying who she stood in. Nope, you right. She came in 14. She came. And I lived with her. Came in February. And said, yeah.
Which one?
Yeah.
Yeah, this say.
Yeah.
They're here?
I just wanna see what.
One for the money, two for the car. I don't know. I don't know.
Yeah.
Okay.
Trey Bonds, McCree.
It's not like you don't have your OIC.
Yeah, with that Jefferson.
Sometimes that's all you need.
Let me make sure.
It's like on your. There you go. Martin.
It's 11 o'clock.
Yeah, I'm not looking for that case. I'm calling her. Who's calling her? Me. I was calling for another case out there. I'm about to do this. Oh, well, it's really a 10:45. So
I know, that's why.
wait before then.
Oh, okay.
Wait before. Yeah, she's coming back.
So, yeah.
Yeah.
I hate it.
Good morning, Council.
Yeah, we signed the waiver form, you know, so we the wrong address for it, so I want to give the court the right address. They had the address of the incident occurred. That wasn't his address.
And that's the address that goes on, we're talking about on the waivers.
Yeah, on the waiver for the preliminary exam.
Where's the file?
Yeah, they didn't have his address.
They wouldn't have his address.
Oh, they would have the address. Okay, so it's
It's just the
correct.
waiver of the incident.
Okay, yeah, and it was correct.
His address should be on the right side, you see.
No, I didn't. I saw that one and it stuck out. Yeah.
Mhm.
Oh,
That's the location.
Yeah, that's the incident. His address should be- Is that his address? 299, no?
Is that a?
Yeah, it looks like, because they didn't even put Detroit, they put unknown, no zip code. So they probably
Because
put
I
the
think
address of
because
the
that's the,
incident.
you know, that's the, that's the Georgia address.
Okay, what's the address?
10226. Lena, L-A-N-A-R.
Detroit, right?
Yeah, Detroit, Michigan. Okay. Yeah, that's Georgia.
That's a nice pen.
I'll get you.
I just
No, I'll get you.
sanitized
But
because
I
I
get
didn't
you
want.
one, so I'll get you one, right? And I have an extra one. There.
So are we ready on Trayvon McCree?
Well, that's the two minutes, so it's still waiting on Jefferson.
I mean, he's waiving, he can do the waiver, right, Judge?
Okay, we can move it to.
Unless you're objecting to it.
I mean, I would just rather do them together.
Oh, we got this already.
So if the other one decides not to waive, what's your position?
I can still proceed, even if he,
So why do we have to do them
yeah,
together?
it's fine, yeah.
Okay, I'll move the table right here.
Huh? I mean, I rather do them together too, it's easier.
Yeah.
Yes.
To get them out is easier.
Right,
At the same time.
But change it now.
Okay. Parties ready on Trayvon McCree, calling case number 24-57225. The people of the state of Michigan versus Trayvon McCree. Defendant number 1 is charged with count 1, weapons carrying concealed. Count 4, weapons, firearms, devices to convert semi-automatic to automatic. Count 6, weapons felony firearm. This matter is scheduled for exam.
Good morning, Your Honor. Asia Lewis from the People, PA 5520.
Good morning, Your Honor. Attorney Edward Bell on behalf of Trayvon McCree. P number is 61827.
And what's your name, sir?
Trayvon McCree.
Is the date and time set for preliminary examination, Mr. Bell?
Yes, Your Honor. At this time, I've spoken to my client of the importance of a preliminary exam. And at this time, he wishes to waive his right to the preliminary exam, Your Honor.
Mr. McCree, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Sir, you understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. And you'll be bound over to Wayne County Third Circuit Court as you stand charged with the complaint form. You understand that?
Yes, Your Honor.
You understand the nature and the purpose of a preliminary examination? Do you understand the nature and the purpose of a preliminary examination? You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, and if there's probable cause to believe you committed it?
Yes, Your Honor.
Is anyone forcing you to waive your right?
No, Your Honor.
Has anyone promised you anything?
No, Your Honor.
Are you waiving your right freely and voluntarily?
Yes, Your Honor.
Any objection from the people?
No objection, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court. Criminal Division for further proceedings. His arraignment on the information date and time will be June 20th, 2024 at 9:00 a.m. And bond will be continued. There's no objection.
No objection.
Bond continued.
And I'll have to check later to see who will be the judge for that, correct, Your Honor?
Yeah, it's gonna be randomly drawn.
Right.
Find that out across the street, I suppose.
All right, thanks a lot.
Thank you.
Thanks, Judge King.
Have a good day, sir. Mr. Wise is here on bond.
Ms. Jefferson. Let's see what she gonna do.
Mr. Jefferson,
They're gonna waive
Hey,
it.
Judge, how you doing?
why do you treat me so bad?
Judge,
I
I've been
thought
on
we
my
were
way,
cool.
I've been on my way,
I'm sorry?
I've been on my way, I actually was on Zoom doing a trial on the way down.
The one I just did?
Yeah.
You always do me like this, though. I'm starting to think it's intentional.
You know I'm not, Judge, you know I love you, dearly.
Save your shoes, the socks are gone.
What?
You wanna get that? Save your shoes.
Socks are
Save your
gone.
socks, the shoes are gone. I said it backwards. My bad. Save your shoes, save your socks, the shoes are gone.
Your shoes
All
are
the
gone.
BS.
Save your socks. Your shoes are gone.
So where's she go now?
They're gonna sign the waiver. Well, I can bring her in and do it too.
They could do that in here. Guess they want to explain, right?
Mr. Wallace, he knows, he's on time. Good morning, Mr. Wallace.
Morning, Judge, how are you?
Doing well, how are you?
Good.
Attorney Hamilton, how are you today?
I'm good, how are you doing?
Good, you were bright and early as well. What are we doing on your case? Why are we holding Ms. Wallace? Ms. Hamilton?
Why can't we do, Hamilton's case?
Yeah, that's what I was just saying.
Oh. I think they forgot about you.
For the people that's on time.
More me like dismissal, Judge. Well, yes.
I don't have any control over that.
Oh, where the prosecutor at? Tyrone.
You're calling Tyrone?
Yep.
We ready?
Asia, so you ready on Jones?
Yeah.
Calling case number 2457331, the people of the state of Michigan versus Eric Jones. The defendant is charged with count 1, stolen property, receiving and concealing $20,000 or more. Count 2, stolen property, receiving and concealing motor vehicle. This matter is scheduled for exam.
Good morning, Your Honor, Agent Lewis for the people, P 85520.
And good morning, Vanessa Hamilton, P82107, on behalf of Mr. Eric Jones, who stands to my right. Could you say your name for the record?
Eric Jones. Today is the date and time set for preliminary examination. Are the people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
Do you have any preliminary matters before you call witnesses?
No, Your Honor.
How many witnesses do you have?
2, Your Honor.
We'll call your first witness.
At this time, the people will call Detective Leonard, Kenneth Leonard.
What's his name? That's
Sir, please step forward, give your name and spelling to the court reporter.
Kenneth, K-E-N-N-E-T-A. L-O-N-A-R-D.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat in this box. Good morning. Maybe again when you're ready.
Could you please state your name and occupation for the record?
Detective Kenneth Leonard.
And Detective Leonard, do you work for the Detroit Police Department?
Yes, ma'am, I do.
Any particular unit?
Commercial officer.
And were you working in that capacity on May 21st, 2024?
Yes, I will.
And did you have occasion to speak to someone by the name of Deanna Todd?
Yes, I did.
And what did you speak to her concerning?
Her vehicle being stolen out of Kenyon Township.
Okay. Did she indicate the type of vehicle?
Yes,
Could you please state that for the court, the type of vehicle?
it was a Dodge Durango, gray in color,
Okay. Did she,
Green?
gray in color.
did she indicate the value of that vehicle?
Yes,
What was the value of that?
I have to refer to my paperwork to give you that accurate.
Would referring to your report refresh your recollection?
Yes, ma'am, I will.
Do you have your report with you or do you need it?
Yeah, I have one.
Okay, go ahead and, well, which one are you looking at?
I'm looking at my investigation.
Okay. That's good. And may I just see that for the, just to show the defense counsel, your honor, may I approach?
You may.
All right, please review that, and when your recollection is refreshed, will you please let the court know?
$80,000.
Okay. And did she indicate the VIN number?
Yes, she did.
And could you please state to the court at least the last six digits of that VIN number?
Referring to my paperwork once again.
Would reviewing it, refresh your recollection?
Yes, ma'am, I will.
Please review it, refresh your recollection, and, let the court know.
Thank you. 696-228.
And did she indicate to you the last time she had seen that vehicle?
Yes, she did.
What was the date?
Referring to my paperwork once again. May 18, 2024.
Okay. And did she, indicate to you whether or not she had given anyone permission to take that vehicle?
She did indicate, the indication was that no, she did not.
Okay. No further questions.
Cross-examine.
Detective, when you were referring to your paperwork right there, you were referring to the investigative report that you prepared. Are you officer in charge on this case?
Yes, sir, I am.
Okay, and so when you're looking at the VIN number and things of that nature, is that something that you took down speaking personally to Ms. Todd?
Yes,
Okay, but you're a Detroit police officer, right?
that is correct.
And this happened in Clinton Township, is that correct?
Her vehicle was stolen in the township, yes.
And so were you the initial detective assigned to that, investigate that theft?
Not in Clinton Township, no, I was not.
Okay, so was this the first time that this theft had been reported?
No, it was reported on May 18th of the movie. I came in contact after a person was arrested.
Okay, and what day was that?
1 moment, referring to my paperwork again.
Yes.
Thank you. That was on May 20th.
So was there a police report that was originally filed at Clinton Township on May 18th?
Yes, it was.
Oh, and is that something that you reviewed in putting together that investigative report?
I reviewed after the fact because I had difficulty getting the report in the beginning,
Okay,
but I do have a report, and unfortunately, my apologies, sir, I do not have it with me.
okay, that's no problem. Is that something that has previously been forwarded over to the prosecutor in this matter, or?
I don't think I forwarded to the prosecutor, but
Okay.
I had the entry from our law enforcement information network that indicated that the vehicle was reported stolen.
Okay. And so when you spoke directly with Ms. Todd, was that on May 20th?
Did we let talk to her on May 21st?
Oh. And so that is that, at this point, is that after the incident why we're in court today? Is that correct?
Yes.
No further questions.
Can you redirect?
No redirect, your honor.
Thank you, sir. You may step down.
Thank you, Your Honor.
And at this time, the people will call Officer Frazier. And that's Valerie Frazier.
Mr. Wallace, what are we doing on your case?
We're gonna move on.
This is a whole, okay. Mr. Bell, we took care of you already, right?
Yes, I just want that prosecutor something is great.
Okay.
Melvin, P-A-L-E-R-I-E, Frazier, F-R-A-Z-I-E-R.
Please raise your right hand. Please raise, swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Please have a seat. Can you get the box next to me? Okay, again, when you're ready.
Can you please state your name and occupation for the record?
Valerie Frazier, police officer,
And, how long have you been a police officer?
4 years.
And were you working in a capacity of a police officer on May 20th, 2024?
Yes,
And on this particular day, were you working by yourself or with a partner?
with a partner,
And what is your partner name?
Kenyatta Martin,
Okay. And were you in full or modified uniform?
full uniform.
And were you in a scout car on this day?
Yes,
And was that scout car fully marked?
yes,
And did your duties as a police officer take you to 7600 Falls Street?
yes,
And is that in the city of Detroit, County of Wayne?
yes,
And why did you go to that address?
for a police run.
Okay. And when you were at that police run, did you come into contact with anyone?
Yes,
Who did you come into contact with?
the victim,
And do you recall the name of the victim?
may I look down
What is it that you're trying to refer to?
my report?
We're reviewing your report, refresh your recollection.
Yes,
And may I see your report just to show defense counsel? Your Honor, may I approach?
You may.
Okay. Please review your report, and when your recollection is refreshed as to who it is that you're referring to as a victim, please let the court know.
Anna Todd,
Okay. And when you made contact with Ms. Todd, where was she?
she was outside of the car.
Okay. And what you said outside of the car, can you explain what type of car you're referring to?
She was outside of her rental vehicle.
Okay, and so was this outside?
Yes,
Okay, and did you come into contact with anyone else?
yes.
Who?
I'm gonna take a second to look down at my report.
We're reviewing your report, refresh your recollection.
Yes,
Okay, please review your report, and when your recollection is refreshed, please let the court know.
Eric Jones.
Okay, and do you see the person you're referring to as Eric Jones here in the courtroom today?
Yes.
Okay, could you please point to and identify article of clothing he's wearing?
Red shirt.
Okay. Your Honor, may the record reflect that the witness has identified the defendant.
So noted.
Okay, and you stated you came into contact with Deanna Todd. Did you speak to Deanna Todd?
Yes,
Okay, and after speaking with her, did you do anything?
yes.
What did you do?
I investigated the vehicle parked in front of the above location.
Okay, and what type of vehicle was that?
It was a Dodge Durango.
Okay, and when you say you investigated the vehicle, what did you do?
I took a look at the vehicle, observed some things about the vehicle, such as the window being busted out, and I talked to the residents at the above location where the vehicle was parked.
Okay, and did you, what was the nature of your contact with Mr. Jones? Okay, when you made contact with Mr. Jones, did you say anything to him?
Yes,
What did you say?
I asked him whose vehicle was that parked in front of the home.
And did he give you an answer?
Yes,
Who did he, what did he say?
he said it was his vehicle.
Okay, and did you do anything to, ascertain whether it was his vehicle or not?
I had the registration for the vehicle. I was able to run it through Lena.
Okay, and when you ran that vehicle through lien, what was the lien result?
It was stolen.
Okay, and after, what did you, do you recall the VIN number, or at least the last 6 digits of the VIN number that you ran through lien?
No.
Will reviewing your report refresh your recollection as to the last 6 digits of the VIN number that you
Yes.
ran through lien?
Yes.
Okay, can you please review your report and let the court know?
696-228.
And when you ran that vehicle through lien, who did that, vehicle belong to?
And that's how.
Okay, and Ms. Todd, was she still there on the scene when you ran that, vehicle through lien?
Yes.
Okay, did, after the defendant who you identified here in court today indicated that the car, was his, did he state anything else to you?
Yes.
What did he say?
He stated that he bought the vehicle from someone.
Okay, and did he say how much he bought that vehicle for?
Yes.
How much?
$5,000.
Okay, and, did he provide any information to you in regards to ownership of that vehicle?
No.
Okay, did Ms. Todd provide anything to you in regards to ownership of that vehicle?
Yes.
What did she provide to you?
Her license, which came back to the vehicle once I ran it through Lena.
Okay, and did she provide anything else to you?
No.
Okay, and did you observe any keys from, did you observe anything from either individual, Ms. Todd or Mr. Jones on that day that would have helped you establish who was the owner of that vehicle?
Yes.
Okay, what did you observe?
Deanna Todd had keys directly to the vehicle. And Mr. Jones, he had a set of keys that didn't belong to the vehicle, but that would start the vehicle.
And as a result of your investigation, what if anything did you do?
We detained Mr. Jones.
Okay, did you tell him why you were detaining him?
Yes.
Okay, and, what did you do in regards to the vehicle?
We recovered it, we took it out of the system as stolen and gave it back to the owner.
Okay, nothing further.
Cross-examine.
Did you ask any questions to Mr. Jones or anybody else on the scene about why the window was broken? Or just yes or no?
I don't recall.
No further questions.
You indicated window was broken.
Yes.
What window was broken?
The rear driver's side window. So
You also said that the defendant had on his person a set of keys that did not belong to the car but could start the car. Can you explain that for me?
well, the keys wasn't on his person, it was in the house when we asked about him having keys to the vehicle, how did he start the vehicle? He told us that he had keys and they were in the house hanging up. We were able to recover the keys because he gave the other occupant in the home permission to give us the keys. The keys did not go directly to the vehicle, it was a red set of keys.
It was
a red key fob that did not go directly to the vehicle, but somehow started the vehicle.
It was a red key fob. So this was one of those remote start vehicles?
Yes.
Well, what makes you say it didn't go to the vehicle?
The key fob went to like a different type of vehicle. I don't remember it, but it went to a different type of vehicle.
So,
And the other set of keys, Deanna Todd's mom had, which she stated.
okay, so Ms. Todd's keys went to the vehicle. What kind of vehicle was this?
This was a Dodge Durango.
Dodge Durango. So the key fob that she had belonged to a Dodge Durango, is that right?
Yes.
And the key fob that he had did not belong to a Dodge Durango,
No.
but it still started the vehicle.
Yes.
Did you notice any other damage to the vehicle aside from the broken window?
No.
Any questions based on my questions?
None from the people, Your Honor.
No, Your Honor.
Thank you. You may step down.
I have no further witnesses.
Nothing further to add.
Yes. Your Honor, at this time, the people will request that the case be bound over. We do believe it's a question of fact, but trier of fact. We did hear from Officer Leonard, who indicated that he spoke with a person by the name of Deanna Todd, who indicated that her vehicle was stolen on the 18th of May. The 18th of May, and indicated that she did not give anyone permission to drive that vehicle and that that vehicle value was about $50,000, at least $50,000. He indicated that that VIN on that vehicle was 6962228. Also hearing from Officer Frazier, who indicated she received a police run to 7600 Cross Street, made contact with a person by the name of Deanna Todd and Eric Jones, the defendant, who she identified here in court. She investigated a vehicle based on the information that she received from Ms. Todd. Upon investigating that vehicle, ran it through Lean using those same 6 digits, 696228, and found that that vehicle was stolen via Lean. Also, further investigation, Mr. Jones stated that vehicle belonged to him. However, in Lean, the vehicle belonged to Ms. Todd. Ms. Todd also stated that she had the keys. Mr. Jones, although having a set of keys as well, Officer Frazier articulated that that key did not belong to the car, but somehow started the car, whereas Ms. Todd had the original keys to the vehicle. And Ms. Todd also indicated that she did not give anyone permission to have that vehicle. The people do believe it's a question of fact, but trier of fact, that's all charged. And I believe that it is somewhat charged in the alternative, Your Honor. As you can see that one is stolen property, receiving and concealing $20,000 more. And the other one is stolen property, receiving and concealing a motor vehicle.
Your Honor, we would object to find over. I don't believe that prosecutors presented evidence to find over on either charge. As you know, the prosecutor needs to present evidence as to each and every element of the crime. In this particular matter, there's been absolutely no testimony as to the knowledge element, besides the testimony that Mr. Jones did not have any knowledge that this car was stolen. He stated that the car was his. He had a key that started the vehicle, and otherwise there's no testimony to suggest that he wouldn't have known it was his, such as sort of damage to a car that would suggest that it has been stolen, such as a damaged ignition, things of that nature. Additionally, Your Honor, there's been absolutely no testimony as to value. We only have the value that the defendant paid for the vehicle, which would only suggest that he understood that he was purchasing a vehicle, not apprehending a stolen vehicle. And Your Honor, so considering that there's no testimony as to knowledge whatsoever and no testimony as to the value of the vehicle, I don't believe that the prosecution has enough time.
There was testimony as to the value of the vehicle.
There's testimony as to the fact that it was purchased for $5,000, Your Honor.
I thought I heard something about the vehicle being worth $50,000.
I don't recall that, Your Honor, but.
Yes. That was during the hearsay statement that Detective Leonard took from Ms. Todd, stating the value of the vehicle.
Okay, well, then in that case, I still stand by that there's absolutely nothing presented as towards the knowledge of the vehicle being stolen, Your Honor. In fact, we've had the opposite.
Your Honor, people would just indicate that it's a question of fact as to knowledge, based on the fact that he bought a car worth $50,000, a 2023 Dodge Durango for $5,000, Your Honor. That would indicate some type of knowledge. A reasonable person maybe wouldn't believe of that type of vehicle is worth at least $5,000. Also, having a red key fob not belonging to a Dodge Durango, but somehow starting a car would indicate some type of knowledge, but that is a question of fact for a trier of fact, Your Honor.
In addition to that, having a broken window in this vehicle, court is satisfied that people met their burden of probable cause. Nobody buys a $50,000 vehicle for $5,000, and you don't even have the right keys to the vehicle. Court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. Court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this has been committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date and time will be June 20th, 2024 at 9:00 a.m. and bond will be continued. There's no objection.
No objection, sir.
Thank you.
Step up here.
Where Mr. Jefferson go?
So I'm starting when you get it, young man, can you step up here? I got it.
Parties ready on Darius Hayward?
Yeah.
Calling case number 2457225, the people of the state of Michigan versus Darius Hayward. Defendant number 2 is charged with count 2, weapons carrying concealed, count 3, weapons carrying concealed, count 5, weapons, firearms, devices to convert semi-automatic to automatic, count 7, weapons, felony, firearms, matters scheduled for exam.
Good morning, Your Honor. Asia Lewis for the people, PA 5520.
Good morning, Your Honor. Competency Jefferson on behalf of the defendant, Darius. Hayward. I don't know why I keep it called. P4272, Your Honor.
Today's the date and time set for preliminary examination. Mr. Jefferson?
Your Honor, after discussing the matter with my client, realizing the statutory right, he does have a statutory right to put an exam. He does wish to waive the exam with full understanding he's going to be bound on the circuit court. Further proceedings on the warning complaint.
Mr. Hayward, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Tell me your name for the record again.
Darius Hayward.
Sir, you understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with complaint warrant. You understand that?
Yes, sir.
You understand the nature and the purpose of a preliminary examination?
Can you repeat that?
Do you understand the nature and the purpose of a preliminary examination? You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, and if it's probable cause to believe you committed it?
Yes, sir.
Is anyone forcing you to waive your right?
No, sir.
Has anyone promised you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No objection, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily and freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court, Criminal Division for further proceedings. His arraignment on the information date and time will be June 20th, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor.
Thank you.
All right, who we got next? Barnes, Mark Barnes?
Yes, boss.
Ready, Ms. Wall?
Yes, ma'am.
1 second, Kitty. We had a big call on the witness that I need, but I'm just gonna double check to see what his partner called to see if we can proceed.
Bars. You did this cross coming and or sliding.
Ready?
Yes.
Parties ready on Mark Barnes, calling case number 24-57294. The people of the state of Michigan versus Mark Barnes Jr. The defendant is charged with count 1, weapons, firearms, possession by a prohibited person. Count 2, weapons, ammunition, possession by a prohibited person. Count 3, weapons carrying concealed. Count 4, weapons, felony, firearm. Count 5, weapons, felony, firearm, habitual offender, third notice. This matter is scheduled for exam.
Good morning, Your Honor. Agent Lewis for the people, PA 5520.
Good morning, Your Honor. Good morning to your staff. My name is Ted Wallace, PA 0922. I represent Mr. Mark Barnes, attorney stands on the right.
There's date time set for preliminary examination. Are the people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
How many witnesses?
Just the ones.
Do you have any preliminary matters before you call your witnesses?
Yes, Your Honor, one preliminary matter, the people do move to admit, the people propose exhibit number 1 pursuant to MCL 76611A, the certified copy of the register of actions of the defendant's previous felony conviction of carrying a concealed weapon, with the sentencing date of August 11, 2024, where the defendant has not, fulfilled all those requirements. The date of the- I've shown opposing counsel, would you like to see her? 2014. August 11, 2014.
Any objection?
No objection for preliminary exam purposes.
Admitted.
Thank you, Your Honor. At this time, the people will call Officer James Stewart.
Your Honor, the defense would ask for a sequestration of any other witnesses that may
It doesn't look like or appear that any other witnesses are in the courtroom. Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm going to log off at this time.
May I ask for an exception for the officer in charge who is not testifying here today? Could you please stand and state your name?
Detective Campbell Smith.
Any objection?
No objection.
Okay. Sir, please step forward, give the name and spelling of your name to the court report.
James Stewart, JamesStewart.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat. The witness box next to me. You're ready.
Can you please state your name and occupation for the record, please?
James Stewart,
And what do you do
I'm a police officer,
with what department?
Detroit Police Department,
How long have you been a police officer?
going on 2 years.
Were you working in the capacity of a police officer on May 18, 2024?
Yes, ma'am.
And on this particular day, were you by yourself or with a partner?
I was with a partner,
Okay, what's your partner name?
Ian McBee,
Okay. And were you working in full or modified uniform?
modified uniform.
Now, when you're working in modified uniform, what exactly identifies you as being a police officer?
We have a police name tag with the Detroit badge and it says police officer on the front and back of our vest.
And on this particular day, were you in a scout car?
Yes, ma'am.
And was that scout car fully marked or semi-marked?
Semi-marked.
And when a vehicle is semi-marked, what identifies that as being a police vehicle?
Says Detroit Police on the side of the vehicle.
And did your duties take you to the area of Furwood and Workplace Street?
Yes, ma'am.
And is that in the city of Detroit, County of Wayne?
Yes, ma'am.
And what were you doing in that area?
We were on patrol in the area, driving by.
Okay, and while you were on patrol, did you observe anything that caught your attention?
My partner informed me.
Well, not, without stating what your partner informed you, did you receive some information from your partner?
Yes.
And based on that information, did you do anything?
Yes.
What did you do?
We exited the scout car and we approached Mr. Barnes.
And the person you're referring to is Mr. Barnes. Do you see him here in the courtroom today?
Yes, ma'am.
Could you please point to an identified article of clothing that they're wearing?
He has a plaid flannel on
Your Honor, may the record reflect that the witness has identified the defendant?
So noted.
Okay, and we, as you approach Mr. Barnes, did you observe anything further?
Yes, an L-shaped bulge on his right hip.
Okay, and as a result of your, observations, what if anything did you do next?
Once we approached him, began to place him in cuffs, and as my partner patted him down and recovered the weapon.
Okay, and why did you, begin to place him in cuffs?
We detained him just in case, he didn't have a CPL.
Okay, and did he have a CPL?
No, he didn't.
Okay, how did you ascertain whether he had a CPL or
I
not?
ran it via Lena.
Okay, and did you, speak with the defendant, did you ever ask the defendant whether he had a CPL?
I personally did.
Okay, did your partner?
Yes,
Okay, and did he answer?
yes,
And did he indicate that he had whether he had a CPL or not?
he didn't have a CPL.
And did he indicate that before you ran it, via link?
No.
Okay, and, did you observe your partner do this pat down?
Yes, I did.
And did you observe your partner recover this weapon?
Yes, ma'am.
And is where your partner, recovered the weapon from, were you seeing this L-shaped bulge?
Yes.
Okay, and can you describe that, the gun that was recovered to the court?
It was a black Glock.
Okay. And did you tell the defendant why you were, putting them in cuffs before you did?
No.
Okay. No further questions.
Cross exam?
Yes, right. Morning, officer.
How you doing, sir?
Good. Just to be clear, so you, where were you in the vehicle?
I was in the right passenger seat, front passenger seat, sir.
Okay, and you were driving down Furwood? Or?
I wasn't driving, I was just in the passenger seat riding.
Okay, you're riding down Furwood?
Yes.
Okay, and where was my client?
He was in front of a food truck.
Okay,
On the sidewalk.
Where was that food truck?
On the current corner of Furwood and Workplace, right in the left-hand corner.
Okay, how far was he about from your vehicle?
I couldn't say, couldn't give you a.
100 feet, 200, and he was right on the corner?
I would say he was about 50 feet from the corner in front of the food truck where the food truck was parked.
Then another 10, 20 feet from where you were sitting?
I'm not great at math, sir.
Well, that's not math, that's just, okay, so you were in the passenger seat, you didn't see anything, right?
I didn't see anything immediately, I was observing the crowd.
Okay, how's the crowd, what kind of crowd was there, how many people were there?
Maybe 50, 60 people.
50, 60 people. And so
It was a biker club.
Okay, you didn't see anything until when?
When my partner alerted me when we were walking up. We exited the vehicle, he alerted us, we're walking up and I observed the L-shaped bulge on his hip.
Okay, so before that, you hadn't seen anything, you didn't recover the weapon?
No, I did not recover the weapon.
Okay, and he was standing, my client was standing about 50 to 70 feet from where you were sitting originally?
I would say 50 feet, I wouldn't say.
How was he standing?
He was facing the food truck, so straight ahead, and his right hip was towards us.
Okay, what was he wearing?
He had a white t-shirt on, black jeans, and the same black Tim's he has on today.
I'm sorry?
He has the black Timberland boots he has on today. He had those on the day he was arrested.
I didn't even see those shoes. That was pretty good. And you say you saw the L shape while he was standing at the food truck?
L-shaped bulge when we were approaching him.
Okay.
That's when I visually saw it.
And when you approached him, he was still facing the food truck?
No, he was facing us when we approached him.
So you saw the L shape when he was facing you?
I seen the L-shaped bulge when we were walking up, because my partner mate talked to him. He said something to him. That's when he turned around and looked at us.
Okay. So when you were approaching him,
I seen the L-shaped bulge when I was approaching him.
Okay, when he was facing you.
When I was approaching.
So you saw the L shape. It's not your question. When you were approaching him, he was facing you, correct?
Yes.
And you saw the L-shaped bulge on the right side?
Right, yeah. Yes.
Okay. All right, thank you. I don't have any more questions.
Any regrets?
No regret, Your Honor.
Sir, the weapon that was recovered, was it loaded?
Yes, it was, sir.
How much, or how much ammunition was in the?
Sir, I didn't count the amount of bullets in the firearm.
Was the item placed on evidence?
Yes, sir.
What was the evidence number?
Sir, I cannot recall the evidence number.
You have something that'll refresh your recollection?
Not on hand, sir. No, it should be noted in one of the
You have
reports.
something that will refresh the officer's recollection?
Yes,
That's what it is.
this is his, partner's report.
Anything has to be
Anything
used-
can be-
anything can be used to refresh recollection.
May I approach your honor? Please review the report and when your recollection is refreshed as to the evidence tag number, please let the court know.
The evidence tag number is.
Wait, don't read it. You look at it and then try to remember it and then say it.
Your Honor, I would object. He's the officer testified, he's not the one that recovered the weapon, and there's no indication he's the one that put the weapon in the evidence. So for him to testify what that number is, would be hearsay.
May I speak? Your Honor, the people would, state that the officer has personal knowledge that it was placed on evidence.
That's what he indicated. When I asked the question, was the item placed on evidence? He said, yes. And I asked him, "Do you know the evidence tag number, do you remember the evidence tag number?" He said, no. So he said that his report will refresh his recollection.
He's not even using his own report to see.
He
if he recovered the weapon.
used to refresh recollection.
I understand. I just saying I object to the hearsay.
Overruled. May proceed.
Can you please state the, evidence tag number for the record?
2405170404-1.
And that report also refresh your recollection as to how much ammunition was in the weapon?
No, sir.
Can you please review it? I don't think you looked at it. Can you please review it and, if your recollection is refreshed as to how many, how much ammunition was in the weapon, please let the court know.
There were 10 live rounds in the weapon.
So were those live rounds separated from the weapon? When you placed it on evidence?
No, sir.
Okay, so you kept the live rounds in the weapon?
Oh, no, sir. No, sir. They were in the same evidence folder, but the rounds were not in the weapon itself.
Okay, so the ammunition was removed from the weapon and counted, they were counted and it was 10.
Yes, sir.
Any questions based on my question?
Nothing from the people. Thank you.
Thank you, sir. You may stop.
People have no further witnesses.
Any witnesses for the defendant? People?
Your Honor, the people will request that the case, be bound over. We do believe it's a question of fact. Officer, Stewart received information from his, partner upon which, he then began to approach the, defendant who he identified here in court today. On approach, he did see that, an L-shaped bulge upon which he, approached the, defendant. He observed his partner pat the defendant down and recovered the weapon from where he saw that L-shaped bulge. At, Your Honor, there was also testimony that the, weapon was loaded, and the people also presented the, register of actions of defendant's previous felony conviction, which would make him ineligible to, carry a concealed weapon.
Mr. Wallace?
Your Honor, we would object to the bind over based on the fact that, Officer Stewart did not observe anything from, before Mr. Barnes was approached by the police, and he also did not recover the weapon. And furthermore, the possession of the ammunition, that charge, that there was not, the ammunition was with the gun, it was in the gun. I liken that to arresting someone for being in possession of a stolen vehicle and then charging them for being in possession of stolen gas. It was all together. I think that it's,
Except for there's no statute for stolen gas.
yes, there is.
There is?
Stolen property, Your Honor.
No, I said stolen gas.
I know, but wouldn't stolen gas be stolen property? It was.
See, there is a specific statute for stolen for possession of ammunition.
I understand
If
that.
there was a specific statute for stolen gas, that would be something different, but just the theft of gas, it's not the same.
Well, I mean, I would submit that having a separate magazine of ammunition or a box of ammunition would be what that statute is meant for, not for the bullets inside the gun. So based on that, I would object to the bind over on all of the counts.
All right, so your argument is that the legislative intent was not to have guns that had ammunition in them, but if there was ammunition separate and apart in addition to a gun, that's what they were referring to.
Yes, sure.
I think you may be correct, but I'm not sure about that.
Thank you.
I have no rebuttal as to that, because based on the fact that this is how we pretty much have charged it. I believe it's been charged both ways, Your Honor. So I don't have an argument as to that, but I still do believe that that's a question of fact for the trial.
I tend to believe the legislative intent behind the possession of ammunition is like Mr. Wallace indicates, that when you have ammunition separate and apart from the gun. But I don't know if we have any settled law on that point. Because you can have a gun and not have ammunition to the gun. And by virtue of the gun having ammunition in it, it makes it even more dangerous, as opposed to just being in possession of a weapon. So I'm going to err on the side of caution. I'd like to see where that ends up, Mr. Wallace. I'm sure you'll look further into that. And once you do, give me some clarification. Because I tend to think that you're correct in that, but I'm not entirely sure. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. Doesn't matter if this officer didn't initially see the bulge himself. He eventually did, even though he didn't initially see it. When he approached the defendant, he saw the L-shaped object, and that L-shaped object turned out to be a weapon. Court is satisfied. We'll bind the matter over to Wayne County 3rd Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 20th, 2024 at 9:00 a.m. The bond will be continued.
Thank you, Your Honor.
There's no objection.
No objection, Your Honor.
Have you had similar arguments like that before, Mr. Wallace?
I did a last minute trial in front of Lillian, or not Lillian, Keanu Lillian, yes. And I just got the case like 2 days prior to that, and that was in my directed verdict argument. She said she agreed with the argument, except that she didn't agree with the timing of it. There's no trial. But it seems weird to me that because when I was an APA, I would charge it if they found a box or if they found it someplace else, but once in the gun, it's kind of just part of the gun at that point, is in my head, and I don't think that would make much sense.
The only thing, if I'm arguing that part on behalf of the prosecution, I'm gonna argue that having a gun is one thing, having a loaded gun is another.
Right, but in the statute for having a gun, it doesn't matter whether or not there's bullets, it's still.
Exactly, that goes to my point,
Yeah,
that you just have the gun, that in and of itself is a felony.
right,
But having a gun with bullets, and the bullets makes it another felony.
right. Yeah, I thought it was a kind of just a cheap charging shot by doing most of that. It's like something like a throwaway charge.
You expect if someone has a gun, it's gonna be loaded.
Right.
What uses a gun without it being loaded?
Right, exactly. And the way some people shoot, it doesn't even matter if it's loaded.
Right.
No, thank you.
Yes, good, Ronald.
Could have made some law, you know?
You still might.
That's true. It's no longer to try to look good, it's just meant to die.
Right. Any sign of Ms. Cross or Mr. O?
Mr. O called, he's across at Frank Murphy. Say he's wrapping up on there. No sign of Miss Crawl.
See if I can track down the facilitator from Mr. Cripps.
And both of the defendants are here, Judge.
Okay.
Thank you, Judge.
Yes.
Have you been down to the new train station here?
I have not. How about yourself?
No, I can't wait to get down.
Are you going to this concert there?
No, you supposed to buy tickets, I think.
Tomorrow, I'm going.
You going?
Yeah,
You
my
got tickets?
sister got tickets.
Okay.
So she lives in Corktown. They gave them like first
Oh.
choice at tickets. Take my bag. Huh? Yeah. Yeah, he thought it was gonna be another train station.
Yours might be ready, Judge. Yours might be ready next door. It's 11:51.
Oh, you got a
It might be worth a try.
Was it set for 12 or 12:30?
Oh,
I think it's set for 12:30.
I have a 12. I see a 12 on my docket.
Oh, maybe it is 12. I'm reaching out to Ms. Cross now.
Okay.
But I don't have a reporter over there, right?
Yeah, if you want to do the. That's okay.
We'll just send the work back to her.
Okay.
I just called my courtroom and this is what I'm getting. That's not right. is it? Let's try that again. My phone does stupid stuff.
Maybe she put you on hold right away.
Yeah, right.
Maybe she could have hit hold. I think that is the music for hold.
Nobody's showing up yet.
Two crosses.
Yes. Yeah, I wouldn't be surprised. It's a DV. We haven't seen Miss Drain. Oh, okay. Okay, thanks.
Yes. Yeah, you got hair.
Oh, you good, go there with.
That's fun.
And you think I had.
And you only got,
Here, we can check out.
oh my God. That, yeah, oh my God. Yeah, you can tell that shit. Is Terry next door? He's working next door?
Yeah.
Told the prosecutor to measure the court. Cause you know how they, sometimes they ask the witnesses the distance.
I'm sorry, let me get your appearance, Ms. Drain.
Thank you. Good afternoon, Your Honor. Shelley Drain for the people, P number 60249.
And Elliot Margolis, P28078, on behalf of Ms. Chapman. State your name, Ms. Chapman.
Today's the date and time set for preliminary examination. Are the people ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness was notified of today's date and time for the exam, and he is not present. I cannot proceed without his testimony today.
Move to dismiss, Judge.
So ordered. The court will dismiss this matter without prejudice.
Thank you, Judge.
Thank you. Yes, ma'am. Okay, I appreciate that. Thank you. Hi, Mr. Roberts. This is Judge King, 36th District.
Oh, Judge, may she have an order to?
Hold on.
Covering Judge Dockett and Judge Giles Dockett. You had a competency hearing scheduled for Rick Watts. Clerk, you're trying to get in contact with you since Monday. Left several messages. Are you able to zoom in to do this competency hearing? Yes, right now. Perfect.
Mr. Markello. Mr. P number.
P number 28078.
Sure. 360-233-0000. Okay, thank you. What did you have, Mr. Margolis?
May she have her tether removed as well?
The dismissal order should take care of that.
Thank you.
Okay. And Ms. Roberts is zooming in now. It's my soothing voice.
Oh my God. Judge King is. Yeah. Yes, thank you. All right. This one. Wow.
What?
She's
Hello there, Ms. Roberts.
Hi.
No? Who are you?
Yeah, no, it's her. It's her, Judge. It's not who we thought it is.
Oh.
That's her. I mean, that is her. All right. Wayne County Jail said give him 5 minutes. You need him, right?
She's gonna wait. Ms. Roberts, did you want to wait on your client or waive his presence?
I can waive his presence, Your Honor.
Okay.
I mean, Miss Robert, I mean,
What you know,
Asia. Yeah, Miss, Lewis. Parties ready on Raekwon Watts?
Yeah.
Calling case number 2360293, the people of the state of Michigan versus Raekwon Watts. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. Count 2, retail fraud, 3rd degree, habitual offender, 2nd notice. This matter is scheduled for a competency hearing.
Appearances for the record, please.
Good afternoon, Your Honor. Agent Lewis for the people, PA 5520.
Good afternoon, Your Honor. Hannah Roberts, P84643, on behalf of Raekwon Watts.
All right, this matter is scheduled for a competency hearing. We do in fact have a report back from the forensic center. Well, maybe we do.
We do, Your Honor. Do you have a copy of that?
Okay, what did they find?
Yeah. Correct, Your Honor. He's been found incompetent to stand trial.
Durable, is that right?
Yes, Your Honor.
You stipulate to those findings?
I do, Your Honor, yes.
People?
Yes, Your Honor. People stipulate to those findings.
All right, the court makes a finding that the defendant is not competent to stand trial at this time, however, is restorable. Therefore, I will refer him to the treatment center for treatment. And I will adjourn the competency hearing to September 5th at 8:30.
And Your Honor, when the people place on the record that we do indicate that this will be the 3rd review and that we may be getting up to that 15-month period where we will likely try to petition for the defendant to go into some type of civil commitment.
Are we there yet?
We're on, this will be the 3rd. Once this next one, that's what we'll be at. So.
When is the date?
1 second, I gotta get the first one. Do you have the first one? The first one? It's my understanding that this is the second finding of incompetency. Is that correct? Is that your understanding, Counselor?
That this is the, I'm sorry, I'm having a hard time hearing that this is.
The second finding of him being incompetent?
That I do not know.
Okay, well, Your Honor, I will withdraw that and then make sure that I do have that information for you on the next hearing.
Okay. So again, the review date will be September 5th, 2024 at 9 o'clock.
It's at 9?
You do 8:30 or 9? 8:30. 8:30,
Okay.
I'm sorry.
That's okay. I just want to make sure I don't screw it up this time. Thank you.
All right, thank you. Have a good day.
You too.
I don't have another finding on here. Asia.
Okay.
Where you at?
I think this is the case that I have.
No, I don't think this is the one. This is the one he got put in jail. He got a capias and it was never determined.
Oh, okay. Okay,
So if you capias during the period of time that he was referred, that's gonna total the statute.
Okay, all right.
Because his PCC was on January 22nd. Capias in February.
All right, yeah, that was the other one, because on the on the first date, we had three counts here. When it's
Right, and then he caveat again.
Okay. All right, thank you.
They said we just need to do Martin, Mr. O, right?
And Ms. Kraus, I thought.
Oh, what Ms. Silver say?
Oh, she said Ms. Cross is on the way.
Okay. Thank you, Judge. I should have told you to call yesterday.
I just have that mind.
Oh my God. She logged right on with no hesitation. Been calling her for 3 days.
Your Honor.
Yes.
You have someone here. Say hi to you.
Oh, hey, how you doing there, Kev?
How are you?
Good to see you, sir. Come on up for a second. Sure.
Watch all the cords, don't trip.
Hey, Kevin.
Hey,
How are you?
You all right?
Yeah, I'm
How you
good.
been?
Good.
Good to see you.
You too.
What's happening?
Smooth, man. I'm doing good. Good to see you.
No. No. I know that was you, Kitty, back there. We had.
Right. That's what I need. When I can't. All right, this has to go to our next. Mr. Crawford, do you feel like going to 439?
Well, I feel like.
That's wrong.
Let's tell them, take this up.
That's the wrong question to ask. Can you take this mid up for Jefferson to sign?
I'll tell Rob, you gotta beg him to take it up. Come on.
All right. Woo, I'm so glad to get rid of Mr. Watts.
Yeah, I know, right? What was that date she gave you?
The judge gave a review for, I think it was September.
September, cool.
Yeah. December 5th. Oh. Courtroom 233. Yeah. So Watts got a review on September 5th. Yeah. I guess he should be going to the forensic center, right? He's not getting treatment. Okay, so once I send this order, they probably take him for treatment. Yeah. 202. So I'm gonna do the order, but I'll send you the name. Okay. All right, thanks.
So that's my car. That's what I didn't check it, but I'm pretty sure tired of this. Who was his attorney? I'll look at it. Appreciate it. Thank you. All right.
Thank you, bro. Good seeing you, Kitty. How you been doing?
You too, Kevin.
How you doing?
I'm doing pretty good. How about yourself? It's good. Hanging in there.
Yeah.
One day at a time.
Good seeing you, Jeff.
Okay, take care now.
Yeah. All right, thank you.
He always got some suits, don't he?
You talked to the wrong guy. Who got?
Kevin always got suits. Well, I know Judge. He ain't
Organization.
That's why they friends. Oh, we suited up. He was like a runner for, I forgot what the term. I remember, yeah, he was always up there.
Where's the cup at?
I know, don't judge me.
I'm not gonna wait on you.
In the
Yeah,
car, I'm
he didn't tell you
gonna-
that? You wear hankies, don't you?
That's I'm asking today, see if you
I'm gonna-
got. Almost forget.
I think I bought
I'm gonna put that.
a couple of them. I forgot what I gave them to. That's how long ago it was. No, I didn't know you, well, yeah, next time.
Did anybody give us an idea how long?
Said she was on her way back from Dearborn.
Oh, how long ago was that?
Come on.
How long ago was that?
Thank you.
Good stuff.
Can I go do something? Do you want me to wait? I mean, I can.
Go ahead, do what you gotta do.
Where Kim go? Where Kim go?
She didn't say, she said she's gonna go do something.
Oh,
I ain't get all of it.
like I am.
Where you go, what you doing?
I'm trying to see if I can go get my lunch.
I don't see why not.
Let me see if they ready up there.
Leave me the file.
Huh?
Just leave me the file. Oh.
I should have did it. Let me do it tonight. Shoot.
It's not right.
What I do?
Look at these copies.
Oh, wrong checks. Okay, sorry. Glad you looked at that. What I do with it? I know it's a lot for that number two. Be back, Judge. I'm gonna go get my lunch from board. For work.
Okay.
Watch.
Hello there, Ms. Cross.
I apologize, Judge.
It's okay. Yeah.
But it's like.
You're usually on time. You get a pass.
Thank you. If I may get a few minutes to talk to my client really quick.
Okay.
It was a long one.
Oh, she's out there.
Yeah.
Okay.
Hi.
So that would be.
I got a few minutes to talk to you. Hi. How are you?
Crawford, can you do me a favor? Can you just take this next door to, Arnita?
So I did the wrong number. I thought it said.
Is there room to put them in there?
I didn't do that. And then Michelle did. Just.
Y'all got snacks?
Yeah, you want some snacks, man?
What you got?
Chips, fruit snacks, crackers, nuts, cookies,
I've got nuts,
biscuit, yeah,
fruit snacks.
yeah. Like all kind of nuts, like these, fruit snacks.
I'll do a fruit snack and a nut.
Uh-huh. One of them.
It says you like to take care of people.
Provide you with healthy snack.
So nobody likes these?
Well, everybody does.
Oh, Terry? What is these?
Oh.
Well, I know he likes these.
Oh, I do the same?
No, they're different. These say omega-3 trail mix. These are keto chocolate.
Let's go.
I was trying to see it, so I know not to find them.
Right.
That nobody's sending it.
My sugar is gone. I mean,
You wrote the judge now, so I can do.
No, I don't know, time, you something.
Yeah. He's hanging in there. Go down there.
Where's she at?
Huh? Was she here? Yeah, she was here. She was there with his brother, Wesley Jackson.
Oh.
Oh, I can remember. Where's it gonna be? It's gonna be Memorial. Him and his brothers.
Judge, we have a waiver.
Parties ready on Lena Jones?
Ready, Judge.
Calling case number 2457110. The people of the state of Michigan versus Lena Marie Jones. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for exam.
Good afternoon, Your Honor, Agent Lewis for the people, P8550.
And good afternoon, Your Honor, Sarah Kraus, P81830, appearing on behalf of Lena Combs, Judge. Just so the record reflects, it is Combs and not Jones. Can I say your name, please? Lena Combs.
There's a daytime set for preliminary examination, Ms. Cross.
Yes, Judge, I have discussed with Ms. Combs her right to have a preliminary examination. She has agreed to waive that at this time.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with the claim of warrant. You understand that?
Yes, sir.
You understand the nature and the purpose of a preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution would have to establish what the crime you're charged with was committed in the city of Detroit that was probably cause to believe you committed it.
Yes, sir.
Is anyone forcing you to waive your right?
No, sir.
Has anyone promised you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No objection, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. Her arraignment on the information date and time will be June 20th, 2024 at 9:00 a.m.
Thank you.
May
I address this?
Your objection.
May I address Ms. Combs' bond, please?
Okay.
Ms. Combs has had a pre-planned trip to Dallas, Texas, since the beginning of May. I do have her flight confirmation here. She is due to leave tomorrow, just for the weekend, Judge, and she will be coming right back to Michigan. I am asking for permission for her to travel at this time. She is
What's going on in Texas?
she is visiting family and friends for her birthday, Judge.
Do you have any objection?
The people have no objection, Your Honor. We will leave the decision in the discretion of the court. I did speak to the complaining witness. There has been no issues since the PPO expired.
Okay. Send me an order to that effect.
Thank you, Judge.
Okay, thank you.
One more, Kitty, one more, Melvin? Martin?
Yep, Martin.
How about Mr. Oh, I thought he was on his way.
Yeah, that's what I thought too. Let me.
Over an hour.
What do you guys get?
Huh? I think it was meatloaf or Captain J wings. I got Captain J wings. I don't really like meatloaf. Huh? I hope so, yeah. My husband goes there and gets the lemon pepper, like, can I just get some lemon pepper?
Don't be those, it's all, depends how it makes.
Well.
They always, you gotta make yourself.
I mean, maybe with some gravy or something, it just seemed like a bunch of meat, just, yeah.
How's your mother doing there, Judge?
She's doing very good.
That's good.
Thank you for asking.
Well, what's wrong? Was she sick or something?
No, I asked because
Oh.
she's, I mean, we were talking about food, that made me think about it.
Oh, he
She's
just,
hell of a cook.
he just trying to get some peach cobbler. Or some mac and cheese. Hey.
That made me think about it.
She right here. Yep.
That's good to see. Now, how old is your mother, Judge King?
She will be 72 this year.
All right. Are you the oldest son?
I'm the only child.
Oh, you're the only child, okay.
Oh. Right. All right. Where's he at, in person?
Oh, is your family really?
Okay. I'll let the judge know. Okay. Yeah, we waiting on Mr. O. All right, I mean. Okay. All right. now. So Judge, apparently there's a case Mr. Upshaw is on that Arlene said that she didn't change the date. It was scheduled for the 7th, June 7th. But it was supposed to be scheduled for today. She didn't change it. So therefore, Ms. Drain is the witnesses. However, Mr. Upshaw is his case. He's here, ready to go on it. So he wants to address it. All over. Courtroom.
You can have Mr. Upshaw step in.
Hey, how are you, Mr. Harris? Yes. Well, no, I'm sorry, we got one more case, but we're waiting on an attorney.
Y'all started out at 3,100 voting.
Oh, that's on the team.
Oh, yeah, I should come up there.
That's what I'm talking about, because that's like. Oh, yeah, like, what's it like? Yeah. Yes, sir, I forgot you.
How you doing there, Mr. Upshaw?
Oh, pleasure, Judge.
So I understand we had a little bit of a clerical error here.
No, the prosecutor's just wrong.
My clerk just sounds like she's taking full responsibility.
Yes, my understanding, yeah, I thought it was 12:30.
Yeah, she said that, she did not, she never put the date in the system. And, I'm standing in for Ms. Drain.
Yeah, I can stand in for it.
Okay, because her schedule is my schedule, so. Problem is, I don't know what my schedule is. I don't have my calendar. I'm not at my desk.
You need to file your.
Yes.
No, he has a file.
I got the file. Wait a minute.
Oh.
Yes.
You did a good job.
What I do need though is my calendar.
Okay.
It might be right inside my desk, or it might be on top of the desk. Okay. I need to know what I'm talking about.
Yeah, yeah.
Is this a recall, Judge? From over there? Is it a recall?
It's from over there.
But you called it once already?
No. I haven't.
Here's Ms. Drain.
I'm trying to.
Yeah, no, that's not what we want, that's 21st.
Hey, Ms. Drain, I'm just waiting on my calendar.
Thank you.
No, that's not it, but I can try it using it. No, that's not it. That's okay. See if we're here. Calling case 2457253. People of the state of Michigan versus Clifford Ray Young. Defendant is charged in count 1 assault with a dangerous weapon, count 2 assault with a dangerous weapon, count 3 and 4 felony firearm, count 5 domestic violence. Defendant has an habitual offender for defense notice. Appearance for the record, please.
Good afternoon, Your Honor. Shelley Drain for the people, P number 60249.
And Your Honor, Ronald Upshaw, on behalf of Mr. Young, P number 435, 74, state your name for the record, sir.
So there seems to be a little mix-up in the date. I know that Mr. Upshaw is here because this matter was scheduled for preliminary examination at this time. For whatever reason, my clerk never entered this date into the system. And my understanding is that Ms. Drain also did not subpoena any witnesses because this was not on the docket. Is that right, Ms. Drain?
That is correct, Your Honor.
Okay. I apologize to you, Mr. Upshaw, and to your client. But because of that clerical error, the court finds it necessary to adjourn this preliminary examination to your convenience, sir. Looking at a date, I think I am wide open June 12th. That's a good day for you.
No, Your Honor.
Not a good day? Hey, tell me what's a good day for you.
Judge, I'm good on the 14th.
Appreciate it.
So good on the 17th. And the 17th is more easier.
The 14th is actually better. I'm wide open on the 14th. Actually wide open on the 17th as well.
Okay, if you're wide open on the 17th, I'll take the 17th.
Okay, the 17th at 9 o'clock?
Yes, Your Honor.
All right. June 17th at 9 o'clock, bond will be continued.
Thank you.
Thank you.
Thank you, Judge.
You're gonna have a good day now.
Thank you as well.
Sorry, maybe I was thinking legislative.
How'd you let that happen, Mr. Huff?
Judge, I tried to let the things know that it was due before here.
We're ready on Martin?
Yes.
Calling case number 2457084, the people of the state of Michigan versus Melvin Martin. The defendant is charged with count 1, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. This matter is scheduled for exam.
Good afternoon. Good afternoon, Your Honor. Agent Lewis for the people, P85520.
Good afternoon, Judge Leno with NDS P83424, appearing on behalf of Mr. Martin, and I apologize for being late.
Your name for the record, sir?
Melvin Martin.
There's a date and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor, the people are ready to proceed. Just quickly, the people would like to clarify for the record that the video regarding discovery yesterday was actually uploaded by the officer in charge on the first. However, that link was not sent with the correct videos that Mr. O was indicating. What I was looking at was the uploads, and it showed June 1st and sent by Muhammad, but that was actually the upload of the new evidence. So the people just wanted to correct that for the record, that the one that was sent by another APA initially was the wrong one, and the new one was sent, was uploaded, but had not been sent to NDS just yet.
But you do have what you need.
I do have it now, Judge, but I appreciate the correction on the record.
All right, so we're ready to proceed.
Your Honor, yes, the people are ready to proceed, and then we have the preliminary drug analysis that people would like to admit under MCL 76611B, stating that the suspected narcotics recovered tested positive for 3.4 grams of cocaine.
Defense has no objection for exam purposes.
Admitted.
All right, and at this time, the people call Officer Briggs, Mitchell Briggs.
Right.
I'm sorry, Your Honor, do you want the test? ICCTR?
Yep.
Last name?
GRIGS.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Maybe give it, right?
Can you please state your name and occupation for the record?
Mitchell Griggs, police officer,
Okay, and where are you a police officer?
city of Detroit.
And were you working in the capacity of a police officer on January 25th, 2021?
Correct.
And on this particular day, were you working by yourself or with a partner?
With a partner,
Okay, do you recall your partner name?
Christopher Smith.
Okay, and were you wearing full or modified uniform?
I was a Class C full uniform, so that would be green pants, black shirt with police markings on my outer shirt, garment, and vest.
Okay. And were you working in a scout car?
Correct.
Was that scout car fully marked or semi?
It was marked on the side with Detroit Police in lettering, I believe. It's referred to as both sometimes, typically semi-marked.
Okay, and did your duties as a police officer take you to the area of Fort Street?
Correct.
In Trumbull area?
Yes,
And is that in the city of Detroit, County of Wayne?
yes.
And while you were, when you were in that area, did you observe anything that caught your attention?
Yes.
What did you observe?
I observed a white Pontiac G6. It was traveling southbound on Trumbull. It disregarded a red light when it was turning left on eastbound Fort. It also had illegally tinted front windows on the driver and passenger window, as well as when I ran the plate in our law enforcement information network, it came back as uninsured.
Okay, and as a result of that observation, what if anything did you do?
I initiated a traffic stop on the vehicle.
Okay, and did you make contact with that vehicle?
Correct, I made a passenger side approach.
Okay, and how many occupants were in that vehicle?
I observed 2.
Okay, and do you see any of the occupants that were in that vehicle here today?
Yes.
Okay, could you please point to and identify article of clothing they're wearing?
The driver is sitting up to your right side, my left, wearing a red and gray and yellow t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
So moved.
And you indicated that he was the driver of the vehicle?
Correct.
Okay, and on approach, while you were approaching that vehicle, did you observe anything?
Yes, as I was approaching the vehicle, when I peered into the driver's compartment, I observed the driver to be reaching with his hand into the small of his back, stuffing a small bag into his pants. I gave him instructions to cease those movements and to put his hands up.
Okay, and did he do so?
Yeah, he did eventually comply. I had to give a couple of instructions.
Okay, and what if anything happened next?
The driver indicated to myself and my partner that he was aware that the vehicle was uninsured.
Okay, and based on that information, what was anything to happen?
It was determined that my partner and I were going to impound the vehicle as it was uninsured.
Okay, and what if anything happened next?
The driver and the passenger were instructed to exit the vehicle and instructed to step over towards our scout car.
Okay, and what if anything happened next?
As the driver was exiting his vehicle and walking towards my scout car, I made some observations that his gait was abnormal.
And when you say that, can you explain to the court what you mean?
He was kind of walking with like a slight hobble. His buttocks and his leg muscles appeared like they were clenched. They were clenched, I shouldn't say appeared. My observations were that they were clenched.
Okay, and what if anything did happen next?
My partner alerted me to the fact that.
Objection, Judge, you're saying?
Okay, I understand. So did you receive some information from your partner?
Yes.
Okay, and based on that information, well, when you received this information from your partner, where were you?
By my scout car.
Okay, and where was your partner?
He was performing an inventory prior to impound of the vehicle. He was on the passenger side.
Okay, and when you received this information from your partner, what if anything did you do next?
Give me just a second, think about how to phrase this. So at some point after speaking with my partner, I made an observation that on the floorboard of the passenger side of the vehicle, there was a small like grocery bag, I believe it was, that had a small fold containing what was suspected to be heroin.
Okay, and did you recover that?
Yes,
Okay.
at some point.
Okay, and what if anything did you do next? Well, let's place on the record, did you make that recovery where was the defendant when you made that recovery?
He was by my scout car. I don't recall if he was actually handcuffed and in the back seat at that point, or if he was still standing next to the passenger door, because I had made a recovery just prior to making the recovery of that heroin fold.
Okay, so you made a recovery from where? From who?
So due to the driver's abnormal gait, I instructed him to stop clenching his muscles, as well as due to the fact that I observed him stuffing something into the rear of his pants. I then shook his pants a handful of times until a small plastic bag fell out of his pant leg.
Okay, and did you recover that small plastic bag?
I did.
Okay, and did you place that on the evidence?
I did.
Okay, and was there anything in this? Was it just a small plastic bag or what?
Yeah, it was upon initial observation suspected to be crack cocaine, a pretty moderate amount. And then it was taken to our prisoner processing unit, narcotics division, and tested.
Okay, so you placed that onto evidence. Do you recall the lock cell number?
I do not recall, but I believe it's in my report.
Would reviewing your report refresh your recollection?
Correct.
Okay. Your Honor, may I approach you with?
You may.
Can you please review your report, and when your recollection is refreshed as to the lock cell number, please indicate to the court.
My recollection is refreshed.
Okay, please indicate to the court the lock cell number.
Nora 0574431.
Okay, and you can.
I'm sorry, 316, 44316.
Okay, thank you. And did you take those to the narcotics unit for testing? You stated.
Yes.
Okay, and do you recall, were you present when that item was tested?
Yes.
Okay, and who tested that item?
It would have been either Officer Brenda Johnson or Sergeant Gaines, I believe. This would be indicated on my lab sheet. It should have been Detective Brenda Johnson.
Okay, and did you stand by for those results?
Yes.
Okay, and were those results positive?
Yeah, it did test positive as a narcotics controlled, Schedule 1 controlled substance.
Okay, and I'll just take you back to after you recovered the plastic bags from his leg, you stated, what if anything did you do?
The driver was arrested, taken to the Detroit Detention Center. He was also issued citations and a misdemeanor ticket for no insurance. The citations were for disregarding the red light.
Okay, and was the vehicle towed?
Yes.
No further questions.
Officer Griggs?
Yes.
I want to go back to the driving stuff. You approach from the passenger side, correct?
Yeah.
And your partner approaches from the driver's side?
Correct.
When you initially approach, you don't see any guns in the car, correct?
No, no guns.
You don't see any drugs. As you initially approach.
Could you clarify what you mean? So
after you get out of your squad car, you conduct a traffic stop, correct?
Correct.
And then you approach the vehicle for the first time, correct?
Correct.
From the passenger side.
Correct.
Upon that initial approach, you don't see any contraband in plain sight, correct?
So what I observed is a plastic bag of suspected contraband. At that particular moment, it's just suspected contraband.
Right, but you weren't certain, correct? It was just a bag at that point. You didn't know what was inside of it.
It contained a substance that was suspected contraband, but no, I was not 100% certain of what that substance was yet.
When you approach the car, Mr. Martin and your partner is driver's license, correct?
That's reasonable to assume, but I'm not positive.
And you're standing on the passenger side, correct? So you can see the interaction between your partner and the driver, Mr. Martin, correct?
Yes.
And Mr. Martin also hands your partner valid registration, correct?
Yeah, I think so.
But he didn't have insurance.
No, he did not.
But he had previously had valid insurance, correct?
I would have no way of knowing that.
Okay. You didn't learn through your investigation that his birthday had just passed, so his insurance had lapsed?
That wouldn't be, those two things don't typically correlate.
Okay. Well, when you get to the car, there are two occupants, correct?
Yes.
A driver and a front passenger.
Correct.
You order both occupants out of the car, correct?
Yes.
You pat down the front passenger.
It's possible, yeah.
You don't recover any contraband from the front passenger?
No.
Mr. Martin is also ordered out of the car?
Yes.
He's patted down and handcuffed?
That sounds correct.
There, you don't recover anything?
I would object and ask that the officer don't speculate, have him testify to what he remembered or anything that could refresh his recollection.
All right, so your partner handcuffs Mr. Martin, orders him out of the car, correct?
I don't recall if he was handcuffed or not, but he was instructed out of the vehicle, yes.
And your partner pats Mr. Martin down, correct?
Again, I can't necessarily say what my partner did or did not do with that. But when he
don't
had
recall,
the driver.
so you don't recall.
Okay.
Do you recall?
I do not.
Okay. And Mr. Martin is just being detained at this point for no insurance, correct?
Yes, and that's not the only reason, but yes. It's one of the reasons.
Okay, and the no insurance, it could be a ticketable offense, correct?
It's a misdemeanor.
But you don't have to arrest in every circumstance, correct?
Yeah, I suppose that's true for any misdemeanor.
You've had encounters in the past where a person didn't have insurance and you've just ticketed them and not arrested them,
So
correct?
that's irrelevant, anything that we done in the past is not relevant to this,
It goes to the validity of the inventory search, whether or not he has discretion to arrest.
What you did in the past, how does that relate into it?
Because it establishes that an arrest does not always need to happen for no insurance, and that was the basis for the tow.
I mean, I get that.
If the board won't allow it, I can move on. Okay. All right, let's talk about this. So just to be clear, Mr. Martin is being detained at this point, correct? Because you have not found any contraband.
Yeah, he's detained when we turn the lights on.
Okay, and you've been an officer for several years, correct?
Yes.
You've been formally trained at the police academy.
Okay.
There are policies and procedures that essentially give you guidelines for your conduct, correct?
Yeah, typically.
There's a policy and procedure for inventory searches, correct?
Correct.
You've been trained on that policy?
Correct.
The policy requires that whenever you're going to impound a car, the vehicle must be inventoried, correct?
Correct.
You must fill out a tow card, correct?
Yeah.
Tow card to catalog all the personal effects in the car, correct?
Valuable personal effects, yeah.
Okay, and the purpose of that is to protect the police from false claims of theft, correct?
Yes.
And to protect citizens from claims of theft by the police, correct?
Mm-hmm.
You didn't complete an impound card in this case, correct?
I don't see why we wouldn't have.
So my question was, you did not complete a tow card in this case, correct?
No, I believe I did.
You believe you did, or you know you did?
I can't say with 100% certainty without seeing it, but I have no reason to think that I didn't. So yes, I believe I did.
Okay, and so your testimony is that you believe you did and you provided a copy to your detective or officer in charge?
Correct, our front desk.
And you knew that would be used as evidence in a criminal case, correct?
Yeah, it has the potential to.
Okay. So going back to the search itself, you're saying you conducted the search of the car?
No.
You're saying your partner conducted the search of the car?
My partner conducted an inventory and then I do a follow-up inventory.
Okay.
Or a walk around of the vehicle.
So is it your testimony that you personally recovered the drugs or that your partner recovered the drugs?
On the floorboard?
On the, let's establish a timeline here. After Mr. Mason is taken out of the car,
Mm-hmm.
he's being detained in front of your squad car in your squad car, correct?
Could you repeat that question?
After Mr. Mason or Mr. Martin is taken out of the car,
Mm-hmm.
he is detained in front of your squad car or inside your squad car, correct?
I'm having a hard, can you ask that in a different way?
It's not, I'm not trying to have a gotcha moment here, but you conduct the traffic stop, correct?
Yes.
You approach the car.
Yes.
Occupants are taken out of the car.
Yes.
And then your partner does an inventory search of the car, correct?
Yes, that's correct.
And it's at that point that he finds the black paper bag, correct?
Yes.
With some aluminum foil.
Yes.
With some suspected narcotics.
Correct.
Okay. Now, during this inventory search, you're observing your partner conduct the search, correct?
Yes.
And when he's conducting the search, you had called for a tow at this point, correct?
I had or hadn't?
You had not called for a tow at this point, correct?
I'm unaware of exactly when I called for an impound. I do know that I did call for an impound at some point.
Okay, but that was after you covered the contract, correct?
I don't recall.
Okay.
It was before or after.
So let's talk about the thoroughness of the search. You observe your partner first search the driver's side, correct?
Yep.
He doesn't recover anything. And then he goes to the back seat, correct?
Yeah, sounds right.
And then you observe him lift up the panel where you can control the windows from the driver's side, correct?
I don't recall if he did that or not.
And then he tries to manipulate the center console and lift up that panel, correct?
I don't recall if he did that or not.
And then he eventually goes over to the front passenger side, correct?
Yeah.
And then recovers some suspected narcotics. Is that right?
Are you saying he recovered them?
Did he recover them or you recovered them?
It's my recollection that I recovered them.
Okay. After you observe that suspected narcotics, you then go back to your squad car, correct?
I don't remember the exact specifics of every movement I made.
So if we could do it this way, if you say you don't recall, I can refresh your recollection with your body can't finish, but I'm gonna do it all in one fell swoop, okay?
Okay.
After you recover the suspected narcotics, you go back to Mr. Martin, who's in the backseat of your squad car, correct?
I don't recall the
Okay.
exact specifics of my movement.
And then you take him out of the squad car, correct?
Yeah, that's correct, yeah.
And he's in handcuffs, correct?
Yeah.
And then you begin questioning him, correct?
Yeah, I'm sure I spoke to him.
You
Yeah,
tell
yeah.
him, I can arrest you right now and charge you with the straight crime, or I can charge you with the federal crime.
Yeah.
Okay, and Mr. Smith makes some statements, correct?
I don't know.
And then, based on your conversation with him, you search him, correct?
Yep.
And then you shake his pants.
Yep.
And then some narcotics fall out.
Correct.
And you recover them.
Correct.
And at this point, you have him Mirandized.
Correct.
Okay. 1 second, Judge. What was the question, Judge?
No redirect, Your Honor.
Thank you, sir. You may step down.
Thank you.
People have no further witnesses.
That doesn't know what this is.
Your Honor, the people will move for bind over. We believe it's a question of fact, for the trier effect, we did hear with the testimony from Officer Griggs. Observe the vehicle, disregard a red light upon which he effectuated a traffic stop. I'm sorry, before he effectuated the traffic stop. Did run that vehicle plate through lane, finding that the vehicle did not have any insurance and illegal window tint. Did a traffic stop upon approach. You did observe the defendant, whom he identified today doing a stopping motion, but in the small of his bag. Him and his partner ascertained that the vehicle would be towed. His partner did a inventory search. I believe Mr. O elicited testimony to which he indicated that his partner did identify suspected narcotics on the floorboard. Officer Griggs did recover that, and then he searched the defendant, shook his pants, to which the black bag that he saw came down his pants, and he suspected that to be narcotics. Did place the items on evidence of the test positive for 3.4 grams of cocaine.
There's some subjects to the mind over the number of people. It kind of reads like law school hypothetical with a number of Fourth Amendment issues here. Before I get into the constitutional arguments, I do want to focus on sufficiency of the evidence as it relates to the contraband found in the front passenger. The suspected narcotics that were found in the front passenger seat were found in a black bag. There was a front passenger in the vehicle. There was no testimony that Mr. Martin was making any sucking or furtive gestures towards the passenger area. It was just limited to his own personal body. So for those reasons, I think there's insufficient evidence to establish that he constructively possessed the contraband in the front passenger seat. I think the more interesting argument is the inventory search argument, and also the Miranda violation, and the statements and information that were obtained as a result of the Miranda violations that led to the search of this person. The court is aware prosecution has the burden of establishing an exception to the warrant requirement if there is a search or seizure. There was a search here. There was no warrant, so it's the prosecutor's burden to establish that an exception applies. The exception they want to rely on first is the inventory search exception. The Supreme Court has said in a case called People v. Tui that in order for an inventory search to be valid, it has to satisfy 3 problems. Number 1, there has to be a lawful impoundment. Number 2, the prosecutor has the burden of establishing that the police follow departmental policies. And third, that the search was not done as a ruse for criminal investigation. The officer testified that he's been trained on how to do inventory searches. He knows what the purpose is, but yet the policy requires him to fill out a tote card, but he didn't do that, or he couldn't recall whether he did that. There was also testimony.
I don't think he knows where his words are. He said, I can't, see, I don't know why it wouldn't be done, which led this court to believe that he believed that the inventory card was filled.
That's fair, Judge. But I think the counter to that is that it's the prosecutor's burden to establish that those prongs are met. They could have brought a tow car to clear up any questions as to whether or not the conduct matched up with the policy, but they didn't. It's their burden.
I just have this sworn testimony, which is evidence.
It is evidence, but it was not definitive. He said, I believe so, or I don't know why I wouldn't have done so. That's not an affirmative meeting of their requirement to establish that it was done in concert or in accordance with their departmental policy. The third prong is that the search can't be used as a route for criminal investigation.
But he didn't say that it was.
All right, I think that this is the area of the Fourth Amendment where subjective intent actually matters. He doesn't have to get up there and say that I was looking for contraband. As the court is aware, it can surmise the person's intent due to external circumstances or their conduct. At this point where the search is occurring, Mr. Martin is not under arrest per the officer's testimony. So he's going into the car and looking at through every nook and cranny, searching for something. But he's obviously not searching for personal belongings because there was personal belongings in the car for his testimony, but he didn't catalog that, which is an indication that he was looking for something more. That something more is contraband, is our argument. The final argument is that as it relates to the recovery of the drugs that were recovered from Mr. Martin's person, that was only obtained through a Miranda violation. The officer testified that Mr. Martin was in the backseat of a squad car in handcuffs, so the custody element is satisfied. He was also being interrogated, and the definition of interrogation is, was the officer trying to elicit incriminating statements? Based on the Miranda violation, they recovered contraband. Any evidence found as a result of the Miranda violation?
How do you get that? How do you get that was based off of Miranda, some Miranda violation? The testimony I heard was that there's something about this gait that was unusual, the way he was walking. He told him to stop clenching himself, and he shook his pants leg. Well, where's the statement?
That's why the timeline is interesting. He says he initially makes those observations as Mr. Martin is being walked from his car to the squad car, and then he doesn't search him. He doesn't do a pat down, he doesn't shake his pants. It's not until after the officer goes back, searches the car, finds something, and then goes back to his squad car, pulls him out of the car.
Let's stick to what you're talking about, though. You said a Miranda violation led to this. What's the Miranda violation?
When Mr. Martin is pulled out of the backseat of the squad car, he is engaging in a conversation with this officer in which he threatens to charge him with state and federal crimes. And based on that, he searches Mr. Martin. It's the content of that conversation that leads.
You do know what Miranda stands for, right?
Yes, Judge.
It stands for statement, and you know what the penalty is.
I'm not asking
for a
that.
violation of Miranda.
Correct, Judge.
It's the suppression of a statement.
I'm not asking the physical evidence be suppressed as a result of the Miranda right violation. I'm saying that the statements and information the officer learned as a result of the Miranda violation form the basis for probable cause to further conduct a secondary search. Without that information, there is no probable cause to justify the secondary search. If the search itself is not justified, then that's when I can ask the court to suppress the evidence on the basis of the exclusion rule, not on the sole basis of the Miranda violation.
I don't even understand how you figure Miranda comes into play here. In that there was no statement that was given that led, I guess you're kind of making a fruit of the poisonous tree.
That's correct, Judge. The fruit is the information that he obtained as a result of the Miranda violation.
What information did he obtain in violation of Miranda?
He threatened Mr. Martin while he's in the police.
Let's say that's all true, that he threatened, okay,
and so Mr. Martin makes some statements to the officer, and that formed the basis for that search.
What statement?
I believe it was my understanding that Mr. Martin makes some statement that he has some drugs on him in the pants area.
I didn't hear that.
That was my understanding. If that's not the court's recollection, then.
No, I didn't hear that at all. My understanding was that his whole basis and reason for shaking his pants leg is because of the unnatural way that he was walking and he was clenching himself. And he told him to stop, and then he shook his pants leg until something fell out. I didn't hear anything about any statement about I have drugs on me.
Well, that's court's recollection, for the court's memory. All right, with that, Judge, that's it.
No rebuttal, Your Honor.
I don't find that there was any constitutional violations, as we know as relates to Fourth Amendment issues. There are less Fourth Amendment protections afforded to a vehicle than there are to a house. That type of thing. The officer, of course, had probable cause to stop the vehicle based on their observations. In addition to that, the officer sorry. Like it was up here. Anyway, as far as the inventory search goes, you're correct in that the officers have to follow their procedural guidelines. And I didn't hear that those were not followed. Could it have been more explicit in terms of dragging that testimony out of the witness and so forth? Perhaps, but the witness indicated that he believed that the card was filled out. His testimony is, his sworn testimony is in fact evidence. He says that it was filled out. So if I were to bind this matter over, he said there was a card and it turns out that there is no card. That doesn't go very well for them. Because he said that there was, and he doesn't believe, but he doesn't see any reason why there wouldn't be the card that is filled out. He indicated that he was going to impound the car because of no insurance. This court looks at the objective reasons for the officer's actions. I can't climb into an officer's head, and so long as they have an objective reason for impounding the car, that suffices. His objective reason for impounding the car was that his car was being operated on the roadway without insurance, which they have a legal right to do. Officers are afforded discretion in what they do in terms of what you tried to bring out, what they've done in the past, in terms of, have you done that in every instance? They don't have to, because officers have discretion as to whether or not they want to. They may have not done it in the past, but did he have the legal right to do so in this instance, in which he did? So I find no fault in the officer's actions in impounding the car. In impounding the car, the officers can conduct an inventory search procedure, following their own procedures. The card should have been filled out. The inventory card should have been filled out. I don't know if there's one or not, but he says that he believes that there is. I'll take his sworn testimony as his word. I have no reason to believe that his testimony was not believable. What was your other point? Constitutional, inventory?
The sufficiency of the evidence of the drugs found in the front passenger, and then the Miranda violation, which.
Okay, so possession can be actual or it can be constructive. I believe the people are relying on constructive possession in that the defendant was the driver of the vehicle, that this item was essentially found in plain view, although inside of a bag. Did he have a right to control it, or did he control it, or have a right to control it, is what we have to determine. That in and of itself is a question of fact to be determined by a trier of fact. Did he exercise some dominion or control over that item, or did he have a right to exercise dominion and control? Or did this item belong to the passenger? Well, one of the things, though, that draws the defendant near to this item is that he had some of the stuff on him himself. So that could convey to a rational trier of fact that he was in possession or he had a right to possess the item that was found in the passenger side of the vehicle, because he himself had similar items on himself. So the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint to warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 20th, 2024 at 9:00 a.m. Bond will be continued if there's no objection.
No objection.
Bond continued.
So the court said the 20th, the 14 days runs on the 19th.
Juneteenth.
I see. Thank you, Judge.
I think they recognize it over in circuit court.
Yeah.
Okay.
Yeah.
The lab report. That's a wrap, right?
Yes.
It is.
Yes.
Okay. You want me to sign off here?
Not big lunch.
Well, ladies and gentlemen, that does it for today. That's the end of Judge Giles' docket. Hope to see you tomorrow, same bad station, same bad time. Have a good day.
Thank you for doing it.
Okay.
Yeah.